Mr Speaker, I rise to speak on the third reading of the Criminal Procedure Bill in the name of the Honourable Simon Power, and to note that to the House that the list of legislation for this one bill covers a whole page, the length of a page, of the order paper. And that is one indication of the complexity of this piece of legislation. The second thing is that some of the pieces of legislation being amended are as old as 1947. These are old pieces of statute, and this bill is an all-encompassing bill to help improve the administration of justice. I am happy to claim some responsibility for this piece of legislation. As a Minister of Courts, I could see that the lines of people going through the court system was getting longer and longer, and despite the fact that we were appointing more judges and building more courts, the lines were not diminishing at all. And the reason for this was that our criminal justice procedure, the administration of justice, was out of date. It was complicated, unnecessarily complicated, and difficult. What should happen is that a person should be charged, they should appear before the court the day after or two after they're being charged, they know what the charges are, and the only other time they should go back to court is when the trial begins. That wasn't the case. There were all sorts of hearings and sub-hearings and call-overs and other procedures that had to be undertaken, and it was a paper-based system, unnecessarily complex and unnecessarily bureaucratic. If we are to improve the administration of justice, the statutes which underpin the administration of justice need to be updated. It is a substantial task, and as you can look, anybody who cares to look down the list of bills that are being amended, they can see that this is indeed a very complex task. It had been started before on a number of occasions. The Law Commission had written reports on it, and when I came across it as the Minister of Courts, people had simply fallen into abeyance because it was too difficult. But with the pressure on our court system, I gave it a nudge, and I'm very pleased to see that the Honourable Simon Power has completed the work. Yes, people have made comments about there's a need for cross-party support on this, and I agree with that. But this Parliament needs to get its head around the fact that it cannot afford to allow statutes to sit for 60 years virtually unamended and expect that the systems that are administered by that 60-year-old legislation is going to keep pace with the changes and expectations within our society. This Parliament is going to have to get seized with the notion that it has a responsibility to constantly update the administration of justice and the legislation that underpins it, even if it is difficult, complex and hard. Because if we continue to allow our administration of justice to languish, unattended and unamended for a long time, it will fall into disrepute in the public's mind. And the system of justice had, because of the way this Parliament had ignored its responsibilities. There are many controversial things in this piece of legislation which others have canvassed, and I don't intend to do that. But I want to leave the record with a simple point, Mr Speaker, that it is Parliament's responsibility to update the administration of justice. Yes, it is legislation which is initiated by the Executive, but select committees can do their work in this area, and the Justice and Electoral Committee can put pressure on administrations now and in the future, as can the Law and Order Select Committee, to have these pieces of legislation updated. It is as much Parliament's responsibility as it is the Executive's. And it is a role which should include the judges, the judiciary. It should include people who are expert in the administration of justice, such as court registrars. It should involve people who are at the bar and lawyers who use it. It should include all groups, including parliamentarians, so that we get a general consensus on what needs to be done to improve the administration of justice. Because if justice is not administered properly, fairly and efficiently, it will fall into disrepute, and the decisions that are therefore administered from that will be in disrepute as well. This is Parliament's responsibility, and I'm pleased to see that it's taken it seriously on this occasion, and I commend this bill to the House.